But the reality is, once you get, it is a lot. Particularly if you're a general jurisdiction judge, you have such a wide variety of law to be conversant in, and to be able to handle different cases. In Vermont, we have big courts and we have small courts. And one of the tough transitions for one of our judges is to get assigned to one of the small counties, because there, one judge does it all. How many of you have counties like that? One judge does it all. Yeah. And it's just coming at you, you know? It's just coming at you, and it's coming at you. When you think that you're safe doing a civil jury trial for 3 days, forget it. The minute you come off the bench, somebody's got a search warrant that they want you to do while you're, during your lunch hour, or they've got a protective order that you need to review and issue an emergency order. So those emergencies just keep coming, and you have to be nimble enough to be able to hop from topic to topic. I think that takes time, and I think judges get better at it, but it takes time.
And I think all of you will, as you're on the bench, it will take time. You'll get more comfortable in doing things, and I would say to you, the minute you get really comfortable, step back and take a look at it to see whether that's a false sense or really you've mastered it. So what kind of roles can these folks, as their careers unfold, what do you see are some of the challenges, or what can they do to improve the administration of justice?
Well, I think there are a number of ways in which judges get involved in improving the administration of justice, and I do think that is our role, to not only improve the administration of justice, but also the advancement of justice. So when it comes to the administration of justice, one of the first areas that I at least got interested in, and for some people it seems very boring, but it's just like anything else. Once you get into it, it gets really interesting, is case management. And what are the processes that we have that takes a case from when it's filed to when it ends, and gets that case through in the right amount of time for that case. And it's different depending on the case. In some ways, one way of looking at courts is this one big triage system, right? You got all these cases coming in, and it's a funnel, and you got to figure out how to move those cases that can. Most of those cases are going to settle. The question is, how are you going to get them there? And then how are you going to, in a timely way, get the cases that actually need the trial, get them their either jury trial or court trial. And that can become a fascinating process. And it's become more fascinating, I think, in the last few years because we have data now. We didn't used to have a lot of data. It was pretty hard to tell what your backlog was because we didn't have really good data systems to be able to give us that feedback. But now we have good data systems, and there's no excuse for judges not to know what their backlog is with those kind of data systems.
You know, it's an interesting question because I think Steve here will probably tell you that even though you wish to be a progressive judge and move case management along, but maybe not everybody, whether a district attorney, public defender, guardian ad litem, will be happy about your wanting to move things forward. So what should you as a judge do to engage these other?
I think Maureen Solomon was sort of the founder of the theories of case management that are actually still in play today, and she came up with these theories and did studies back in the 70s, I think. But she always said, if you don't have all of the players on board with what you're trying to do in order to change, if you figure out where the process needs to change in order to move cases along to get a more prompt resolution, if you don't have all the players on board with you, you can't do it by yourself. The court can't do it by itself. You and your clerk can't do it by yourself. So I think it's one of the first places where judges start to play a leadership role in bringing folks together. The prosecutors and the public defenders, if you're in the criminal division, your family law bar, if you're in the family division, and work with them, listen to them, because in order to work with them and to get them to be engaged in the process, you've got to listen to their point of view, listen to them, and then work on, in a collaborative way, with coming up with a system. And you got to figure out, how's that system going to benefit them? Because if they don't see a benefit in making the changes, again, you don't get anywhere. But I think prosecutors, for example, in the criminal area, prosecutors and public defenders who have humongous caseloads as a result of the court backlog, if you can get them to see that if you can make a dent in that backlog and reduce that backlog, that they're going to have fewer cases and more time to concentrate on the cases that they need to focus on, you can then start to begin to get them engaged in looking at ways to improve the process.
Now, they're dealing mainly with systems that have been put into place, but we do know that change may be different, that they're going to be facing different challenges or problems. What would you tell them about the world ahead that they're going to be looking at? I know when I left the bench in 2000, it was completely different, seriously, than when I went on the bench in 1979, what we were doing and what type of issues we were addressing.
And certainly the curriculum that I had when I came to general jurisdiction, which, by the way, in 91 was 3 weeks, not just 2 weeks. The curriculum, I looked at your curriculum for this, the schedule, and I circled all of the areas that I remembered that were not covered when I came in 91. And I made a list. So I'll just run it by you. Courtroom security, not an issue in 91. Big issue today. Self-represented litigants, not an issue in 91. Big issue. And a lot of work has gone into it. Verbal and nonverbal communication, that was certainly not on the list. Interpreters, nobody really worried much about interpreters back in 91.
Yeah, I can remember when I was on the bench, we had to have somebody who spoke Spanish. We'd say, who's the fella down there in the clerk and recorder's office? Go ahead and bring him up.
Yeah.
A little bit different than what you're facing today, right?
You think you could bring your aunt with you? You know, maybe your aunt could interpret for you. Obviously, treatment courts, mental health courts, drug courts, that was certainly not on the list. Pharmacology I saw on your list of courses. You know, I don't even think that domestic violence, as ingrained as that is now in all of the education that we do and is done nationally, not just for criminal and not just for family, but it impacts the civil as well. And judges really have to understand the dynamics of that. In 91, I don't think we were there yet. I don't think it was on the list. So those are just some examples of the things that now have become topics that are part of your curriculum here. But in 91, we weren't even thinking about it.
What have you seen come into place that would help them as an individual improve their ability? What type of programs have you seen come into place, like mentoring or things like that?
Well, I think in a whole other area that judges get into, and which I really certainly I became very passionate about, is the whole, how can we, once you have been on the bench for 5 years, 8 years, 10 years, how can I give back to those new judges that are coming in? Certainly one way is through judicial education. And going to a faculty development course, which I went to in 2000, my first faculty development course, it was one of the most exciting things I did. It was opened up whole new windows for me and new doors. And then I started teaching at our conferences in Vermont, and I found that incredibly satisfying. But one of the great things about it is, if you teach something, what happens? You learn it. Your learners learn it 50%. You learn it 90%. And the other piece of it is you become a better judge. I think that's also true of coaching and mentoring. There's some really pretty interesting. Massachusetts has just put in place really interesting system where they're using their more experienced judges as coaches, not just for the new judges, but also for judges who are feeling really burnt out and who are not getting a lot of satisfaction, work satisfaction. And it takes some training. You got to learn it. You got to learn the skills. It's not just something that we're born with. But if you learn those skills are really transferable into the courtroom. Really transferable. Listening to people in a way that gets people to think about gets them to see how they did things and how to do something, how they might do things differently. We're trying to do that all the time in the courtroom. But how you do that and how you get people to get there, that's what coaching is all about. So I think those skills are really transferable.
In the time we have remaining, let's talk about a couple concepts. What role they can play in this public trust and confidence in the judiciary, in the judicial branch. What is their role as a judge? What are some of the things we can do? What's your observation of the public trust and confidence?
I think that's one of the big challenges that you're facing, that we're all facing in the judiciary. It's pretty critical, right? This is pretty basic, but it's pretty critical that we end up, that the judiciary, as a third branch of government, remains strong. That's part of our democratic, it's part of the foundation of our democracy. But when people don't have trust and confidence in the judiciary, we're at risk, and the judiciary is at risk. And there's been a lot of studies that have been done recently. The studies looked at the public, for example, questioned did surveys and focus groups. And some of the things that are important to us as judges, turns out are not really that important to the public. And to some degree, we have to change the way we talk about things. So for us as judges, independence of the judiciary, how important is that? Number one, it's big. Independence of the judiciary for the general public, I don't know that they don't, turns out they don't really understand the concept all that well. But they want their traffic court ticket heard in a timely way and dealt with in a way that's fair. And fairness and procedural fairness and the ability to go to court and have their case heard, that turns out to be huge for people. People can walk away with adverse decisions against them and still be positive about the courts if they feel like they were heard. So there's a lot of lessons to be learned from that, and I think the key in the years going forward is how do we translate that into improving public trust and confidence.
Okay. The last one I want to talk about is access to justice. I know that the Chief Justices in every state have committed, that's one of their major projects that they're going to undertake, and I think they've expanded this concept of access to justice. What would you offer them about some of these issues of access to justice?